Welcome to today's deep dive panel discussion on third country data transfers as part of our annual Bitkom Privacy Conference. I'm happy to have you all here. Before I start to introduce our distinguished panel, I would like to spend just a few moments on some housekeeping and certain technical advice. In order to avoid too much background noise, if you could kindly keep your microphones muted, as you've already done. Thank you very much for that. If you would like to ask a question to the panel, or if you would like to share any comment, we'd like to invite you to do that via the Zoom chat box. I will be checking the box regularly, and I would also be inviting you to ask the question yourself or give the statement yourself. If you prefer not to be named when asking a question, you can also direct the question directly at me. In this case, I will place it as a question from the audience, but please keep in mind, if you type questions or comments to the general chat, they will be visible to all participants. Also, the entire meeting will be recorded and it will be available on Bitkom's YouTube channel after the conference is complete. It would certainly be great if you could participate with your cameras on so that we can see each other when we talk, in much the same way as we're doing this at a physical event. In this afternoon's panel, we'll first be having a series of impulses by our panel members, whom I'm going to be introducing in just a moment. And after that, we will be opening up the floor for questions and comments. And we would believe that roughly 25 minutes should be reserved to these questions or comments, so please do keep them coming, even while our panelists are introducing themselves. So without further ado, I would like to introduce our panel this afternoon of distinguished experts. Let's start with John Miller, the Senior Vice President for Policy and Senior Counsel ITI Information Technology Industry Council. He has been a Vice President at ITI for several years, ITI being the preeminent global information technology trade association. He founded and leads ITI's Trust, Data and Technology Policy team, and he is driving the organization's global strategy and advocacy on privacy and data protection, on cybersecurity, supply chain security, government access to data and encryption, artificial intelligence, the Internet of Things, export controls, cloud computing, digital platforms and other technology, internet and data policy issues. He's also a recognized expert on global privacy and data protection matters, and he has testified before the US and the Brazilian Congresses and participated as a keynote speaker or panelist on privacy topics at major events in the US and global markets. These included India, Brazil, European Union, and Japan. He also participates in the Future of Privacy Forum expert group on international data transfers and protection. Before joining ITI, he worked for nearly a decade in the global public policy organization at Intel Corporation, serving as the company's Director of Government Relations and Cybersecurity Policy and Managing Counsel. Next on our panel, we have Mathias Cellarius, the Global Data Protection Officer and Head of Data Protection and Export Control at SAP. In addition to his role as the Global Data Protection Officer and the Head of Data Protection and Privacy at SAP, he further heads the SAP Export Control as a second regulatory responsibility. And his professional experience spans the company's legal, public policy, research, and intellectual property functions. He holds a law degree from the University of Freiburg in Germany and his bachelor law degree with the Higher Regional Court of Karlsruhe. And in addition, he holds a Master of Business Administration, an MBA with the University of Mannheim. Next, we have Frank Ingenrieth, the Director of Monitoring and Auditing Legal Affairs at Scope. It's a subsidiary of Selbstregulierung Informationswirtschaft, a self-regulating industry association interest group in Germany, where he is the Deputy Managing Director. Particularly, he coordinates and manages audit and compliance activities. And he constantly contributes to expert and stakeholder groups. He has in-depth knowledge within IT and media law with data protection as a field of expertise. He passed both state exams, strongly focusing on information and communication law in the first state exam, and deepening his expertise by choosing media and copyright law as the area of focus for his second state exam. He also holds a related Master of Laws degree and passed the theoretical part for professional lawyers in that area. He is a certified data protection officer and data protection auditor and an independent registered lawyer. Before joining SRIW and Scope Europe, he gained experience from different perspectives, including international law firms, IT companies, and data protection supervisory authorities. Finally, we have Lorena Marciano, the Director of EMEAR, including Russia Data Protection and the Privacy Officer at Cisco Systems. She joined Cisco as a Senior Corporate Counsel in 2014 and later has been appointed as their first Privacy Officer, responsible for the entire EMEAR, including Russia. She is responsible for overseeing the risk management, data protection program implementation, as well as external relationships for the region. Prior to joining Cisco, she's been working for 8 years for top-tier national and international law firms in Italy, Belgium, and the United States, with a main focus on data protection and privacy, intellectual property, and competition law. During this time, she was also part of a European data protection and technology law think tank, providing independent policy advice on regulatory frameworks. She's a qualified Italian lawyer and holds a law degree from the University of Rome and a Master of Laws in Intellectual Property and Technology Law in the US. And finally, for myself, my name is Markus Stamm. I'm a Senior Legal Counsel at Nokia. I'm the Vice Chairman of the Bitkom Data Protection Working Group, and for the past 6.5 years have been the Chairman of the Bitkom Data Protection Working Group. I'm looking forward very, very much to our panel of experts, and I would now like to ask our experts for impulses, starting with John, please.
Thank you, Markus, and thanks to Bitkom for the opportunity and to the entire Bitkom team for their work pulling the conference together. We're obviously focused today on third country data transfers, so we're going to talk a lot about Schrems II and its implications, I'm sure. I did want to start by taking a step back just to talk a little bit about the importance of cross-border data flows, which I'm certainly hopeful everyone is well aware of at this point. Companies across the globe in every sector of every size really are united by the need to transfer data across international borders. It's corporate affiliates, business partners, service providers, customers, and others who they are transacting or communicating with. They're also indispensable to how citizens on both sides of the Atlantic and all around the globe live, work, and communicate, and they power the international operations and growth of businesses in Europe, the US, Asia, and elsewhere, as well as transatlantic global trade. There are lots of statistics that are relevant on this point. Focusing just on the EU-US for a moment, data flows underpin the $1.1 trillion total US trade in US-EU trade in goods and services, and a nearly $7 trillion transatlantic economic relationship. So I hope we can all agree that a significant interruption of transatlantic or global data flows would be catastrophic. One other point I'd like to make on this note is just that data localization is not the solution to some of the problems that are raised by the Court of Justice's opinion in Schrems II. There is no direct correlation between where data is stored and its level of protection, and in most cases, localization does not increase privacy. Certainly happy to get more into that topic as well. I do want to make a couple of quick points about the Schrems II decision that I think are relevant from a stage setting standpoint. Schrems II, of course, did not just invalidate the privacy shield with respect to standard contractual clauses and other transfer mechanisms. It was fairly clear in requiring organizations that use these transfer mechanisms to verify on a case-by-case basis whether foreign legal protections concerning government access to personal data meet EU standards. I think those sorts of assessments, requiring them of companies is a pretty tall order. Schrems II also, even though sometimes gets overlooked in a lot of the conversation about the EU and the US, it impacts transfers to all third countries. So while the focus has been on US laws with respect to surveillance and national security, other countries' surveillance practices will soon enter the equation. And in that context, it'll be fair to ask whether the Schrems II court has established a standard that many third countries will actually find it impossible to meet. In terms of the path forward, what solutions are on the table? I guess I'd put the ongoing discussions and work streams that we're tracking in really three separate buckets. Of course, there is the question of updated standard contractual clauses and supplemental safeguards themselves as kind of framed up by the court. We are expecting the European Commission, of course, to release standard contractual clauses soon. And as we understand it, they will try to incorporate some of the supplemental safeguards language included in the court's decision. We've got the European Data Protection Board having set up a task force to issue guidance on supplemental safeguards to companies and other guidance. We've also got just yesterday, the US government issuing guidance to companies regarding US surveillance safeguards and limits, which they hope can inform companies' assessments of what those third country laws are, at least in the US. And of course, many companies and lawyers are hard at work brainstorming privacy and compliance solutions and supplemental measures. And I'm sure we'll get into that quite a bit with the fellow panelists. But ultimately, we're going to need a political solution. And that means governments are going to need to act. And the good news is that there are active discussions on two tracks. I mean, number one is, at least with respect to the US and Europe, an enhanced privacy shield, which would be more of an intermediate or really immediate term step. The EU and US government authorities are pursuing such a framework to address the Court of Justice's concerns regarding US government access to data and also to address redress rights. Ideally, this type of agreement would facilitate the continued use of standard contractual clauses as well by addressing those underlying national security concerns. Then there's also discussion on a more durable multilateral solution and what that would look like. In the longer term, can we make progress on some type of international agreement regarding best practices for surveillance, privacy, and transfers that could possibly get multilateral buy-in? I mean, this certainly seems like potentially a more sustainable and scalable solution to address the need to transfer data to all third countries. And the OECD is one potential venue for this work, and there's already some work that is getting underway, even with some meetings next week. Ultimately achieving a privacy shield in the short term and making progress on new standard contractual clauses with additional safeguards are that's another short-term solution, but really the longer-term solution is hopefully those shorter-term fixes will buy us some time on the longer-term solution. The one other thing I just want to leave you with, and I apologize, I think I'm out of overtime, but I do want to just point out that Schrems 2 is not the only threat to cross-border data flows and third country transfers, at least as we survey the privacy and data regulation landscape. We can certainly get more into some of these topics, but there's a lot of things going on, not only on the privacy legislation front globally, but also with respect to non-personal data regulation in places like India, and also the significant regulatory focus globally right now on artificial intelligence in the EU and elsewhere. So I'll leave it there, and I look forward to your questions. Thank you.
John, thank you very much for this introduction. And next, perhaps we would like to hear from Mathias as part of our panel, who certainly could offer a view of an organization that is heavily involved in cross-border data transfers, and certainly the associated legal issues would be of concern to you. Would you like to give us your thoughts?
Yeah, for sure, I would like to. And I can say that out of both of my roles, being the Group Data Protection Officer as well as the Head of Export Controls, I couldn't agree more with what John just said. International data transfers and data flows are basically the lifeline. It's the blood of our global economy, and we do live in a global economy. It's not just global companies that are dependent on data flows, and not just the economy in itself. It's all of us. If you look at our problems that we are seeing these days, just look at the pandemic that we are currently challenged with, and that's why we all are in a video conference rather than meeting live. The environmental challenges, not to be forgotten, these are increasingly global challenges, and they require global collaboration to resolve them. And in today's times, this means data exchange and data transfer. However, it's also clear that this need for global data exchange does not justify data flow without rules. Let's just remember that data protection was conceived to protect individuals from the undesirable effects of data processing. And also the data transfer rules and mechanisms of the GDPR, which we're discussing today, have been designed to ensure that this protection does not end when personal data leaves Europe, but actually the law follows the data. And agreed, we do allow international data transfers and flows, and we do that for economic reasons, because the data processing may be more efficient somewhere else, but ultimately it cannot be to the detriment of the individuals concerned. That's ultimately what Schrems 2 confirms as a principle, and I and probably we all agree with that. Yet this decision constitutes a challenge for all of us. Global data flows have been established, and in many cases cannot just be interrupted without a severe collateral damage. Infrastructures and services, like global cloud services that we are all using every day, they cannot just be untangled and restructured overnight. So what let's step back a moment, because I don't think that this is what Schrems 2 really requires. So we need to really see what this decision actually means. And all it says, in my mind, it comes down to that a revalidation of the legal environment in the country where the data shall be transferred to is necessary to see where the risks with respect to individuals actually are. And then the second step that it requires is if there are any gaps that may be detected, and every country may be a little bit different here, need to be mitigated to provide for some sort of a protection. And in this context, I think it's also very worthwhile to mention another theme that you see throughout this decision. That's clearly that not every piece of data is the same. Not every transfer is the same, and not every threat that you see is the same. So ultimately, this all means a lot of work for all of us. Entering into standard contractual clauses, which is still possible, is not a formal exercise anymore. It's not just about concluding agreement. It's rather that we all need to do risk assessments now, and then if there are any risks, to work towards reducing the risks. And I agree with John that governments and international trade politics play an important role in achieving this goal. Not everything can be done in the private sector, but we, in the private sector, in the industry, and also the data protection authorities, we can do a lot to reduce the uncertainty. The European Data Protection Board was already mentioned. We also know that the US government has taken up the initiative on its part and issued a position on the Schrems 2 decision itself. So it's good to see that people are talking. And but last but not least, we all have the possibility to come up with a code of conduct. And I know that there are at least 2 in preparation right now, and also some guidelines to overcome the uncertainties with the legal situation. Then last but not least, and I'm not a technical person, but I work with a lot of technicians every day, we can think about technical solutions to overcome this situation. So I'm looking forward to talking to you later about these topics. Thank you.
Thank you very much, Matthias. This was a very interesting insight, and I wonder if Frank, as a member of a body who's been promoting self-regulation for quite a number of years, would have some insights into how this interfaces with potential future self-governance models.
Sure, and I can just say I will have some comments on this regard. So, but first of all, I would like to say warm welcome also from my side, and also a big thank you for being invited to this tremendous conference. And it is amazing to see all those experts and following the panel so far. And I also would like to say, as John mentioned already, several possible actions to tackle Schrems 2, including those that are not deriving from GDPR. That was already massively intriguing to me. So I would like to focus on wrapping up solutions deriving from GDPR, and especially those that may be used at a scale. And the latter, to me, appears relevant as Schrems 2 is, as already Mathias and John mentioned, is by far not limited to the ES or just to privacy shield or standard contractual clauses. It will impact all safeguards pursuant to Chapter 5 GDPR. So, the overarching question is, what are those safeguards that will be existent? And surely everyone is hoping for an updated standard data protection clauses or an updated adequacy decisions, but both mechanisms will require an action and an initiative by the European Commission, and thus they are certainly out of scope for the industry influence regarding the timescale. And as Mathias pointed out, we are not having the time to wait years for any upcoming solutions. We need some solutions right up front. So I was wondering whether there are safeguards which can be driven by industry, and when I'm going this path, I surely think about binding corporate rules, and I must admit, to me personally, those aren't the solution everyone is seeking for, because BCRs do have a very limited scope in applicability. So the second idea I was thinking about is drafting supporting frameworks that will ensure proper application of standard data protection clauses pursuant to Article 46. And this is just to think about the mandatory and ongoing case-by-case analysis as stipulated by the ECJ, because the ECJ mentioned that, sure, standard contractual clauses may be used, but then you have to perform an ongoing analysis of the third country jurisdiction and on your technical organizational measures and whether they are fit for each. And surely those additional supporting frameworks will be helpful. But still there are some questions that will remain. For example, what will be the legal effect of those frameworks? And those frameworks will still dependent on the European Commission to properly update the standard data protection clauses. So consequently, and last but not least, and this is going back to Markus Stamm, who talked about the self-regulatory measures, I was thinking about codes of conduct and certifications, and both mechanisms are for sure in full control of the industry, as the industry will be drafting those mechanisms. And as the industry will be drafting those mechanisms will be ready and easy to be adopted right from the beginning, as any potential obstacles can be already catered into such drafts. But I would like to point it out, it highlighted it very much. Being drafted by the industry is no carte blanche. So codes of conduct and certifications do have the involvement of the European Data Protection Board, and specifically if they become a third country transfer safeguard, the Commission has to be involved as well, and so they have to be approved and endorsed by both overarching bodies. And surely the legal effects of certifications and codes of conduct are identical, but from a personal point of view, I would like to say that I consider codes of conduct to be more fit for this matter in this regard, because I consider that supplementary measures will broadly relate to organizational measures in future. And I would also like to have a short highlight on the experience that we made in this regard, especially as being an independent monitoring body and supervisor in this regard. And I would say it's not the time to lose hope. It's just to take the chances and to take the next steps that are open to each and every stakeholder. And for example, Scope Europe already gained specific experience regarding the cloud computing, as we are involved in the European Cloud Code of Conduct. And we also gained already specific experience in drafting in third country transfers, as we were once mandated by the industry to draft an updated standard data protection clause version by last summer 29. So both experience made it kind of obvious that it's no surprise that there has been recently announced that there has been a recent announcement by the European Cloud Code of Conduct, as they have been initiating a so-called third country transfer initiative. And this will for sure try to tackle those safeguards by drafting a code of conduct for third country transfers. And as a closing remark, and maybe as a kind of opener for this discussion, to my understanding, it's now the time and the need to transparently and clearly indicate and certainly communicate existing issues, and thus to involve the relevant stakeholders to find solutions together. Because what I think Schrems to highlight it, only if any upcoming mechanisms will be trusted and will be broadly accepted, these mechanisms are able to prevent Schrems 3 from happening. So this would be my closing remarks.
Frank, thank you very, very much. And I wonder, Lorena, if you would be able to continue to broaden your view on some of the regulatory instruments Frank touched upon, and perhaps some others. Of course, being in a position of a technology provider who enables cross-border data transfers and provides services to that effect, being affected from an entirely different angle. I wonder, would you share with us your insights into these challenges?
Yes, of course. Thank you, Markus. We're not only a technology company, we are a processor. So as such, we are just right in the middle of enabling transfer mechanisms, serving our customers, and really have to deal with the aftermath of Screams 2. In the same way we had to deal with the aftermath of Safe Harbor, in the same way we actually had to implement all the transfer mechanisms that my esteemed colleagues have referenced to it. So in my, I would say, statement, I would just want to offer the point of view of a practitioner, someone who has implemented all of these transfer mechanisms in his company, and just offer some thoughts and some guidance in this time that is certainly uncertain. So in that sense, as I said, being Cisco, we are indeed a processor in the relationship with our customers, which means that we live through the ability for us to transfer data in accordance with European principles. As such, we have been implementing within our organization all of the transfer mechanisms that my colleague talked about. So indeed, we were Privacy Shield certified, and we still are, because that's certainly still required by the US. So one point maybe that I can offer is that I hear a lot of noise around why companies, US companies, are still compliant to the Privacy Shield. Is because we are required to do so from the US. So we'll continue to be applying the Privacy Shield as it is today until we have a new mechanism in place. We have been actually working a lot with the standard contractual clauses, and that's where I would like also to build upon what Mathias said around standard contractual clauses, not just a legal exercise. I would say it's a truly compliance exercise. I've been one of the ones that actually had to implement it clause by clause within the organization before we're able actually to offer it to our customers. So I know how difficult it is to make sure that your internal policies and processes and guidance are actually meeting the requirements of the SEC, which I find with the new updated version that is coming up, that could be a suitable solution for certain transfer mechanisms. As Mathias correctly pointed out, every transfer is not the same. As such, I think the standard contractual clauses, they offer that ability to allow individual transfer from one company to another one. I've been also implementing and get approved for the BCRs, so the binding corporate rules. That, I would say, the binding corporate rules are a very good exercise and are a very good opportunity for companies to actually prove compliance beyond transfer mechanism, because in reality, you need to make sure that your processes, your policies, as well as the ability that you interact with your customer is actually in compliance to the GDPR to get approved. So in a certain sense, you're not only saying that you're going to flow data in compliance with your principles, but in reality, what you're saying as a company, what we have committed to, is that wherever the data are going within a large organization, we will indeed apply the GDPR. So it's a bit more than that, than just presenting compliance and getting approved. And it's also a lengthy exercise and requires a lot of focus and resources from the customers. As we all know now, neither the BCRs, neither the SECs are indeed can be escape the additional assessment that we need to make, that we need particularly to help our customer make, which is, what kind of additional measures can you offer to make sure that there is unsolicited and unwanted compliance from ingerence from third country that might not give the same support. I think a lot of those assessments really boils down to how you've been preparing up until now. I don't think that Screams 2 is a big surprise. It shouldn't be a big surprise if you've been doing this work, as I did for a very long time. And so understanding that you need to be transparent, that you need to have a way to approach government access requests, having solid technical measures, I think all of that, it's just part of being a good corporate citizen versus your customer versus your employee. Now, it still needs to be seen, and that's where I think it's important that we receive guidance very soon from the DPP, is just understand where do we draw the line? What do we need to do more, or what we have done, is that already enough? The last point that I want to make is about code of conduct. We have also, we're one of the members of the code of conduct for cloud providers, which is right now going under approval of the data protection authorities, so the DPP, and then the European Commission being a European code. And as Frank said, we're going to add indeed a module that builds on the ability to transfer data from the EU to elsewhere. I honestly think that the code of conduct, for the experience that we had so far, even in the approval process, I think they're a very remarkable process, although it's a lengthy one, but it pays off, because essentially it forces the industry to come together to agree on a standard, and that to get feedback from the data protection authorities and the European Commission on whether that is enough, if you like, to regulate an industry, because exactly what we are doing, it is to set rules for cloud providers to abide by, which, if you like, it's broader than the BCRs. It's more, I would say, complete than the SECs, and to some extent it's going to work independently, or where there is an underlying agreement between the EU and another third country. So in that sense, it's valuable, because you get buy-in from the data protection authority, the Commission, and then it works everywhere. And I think that buy-in is probably something that the other two are missing, because they either miss the point, the piece of the European Commission, and they either miss the point of the data protection authority, and then obviously has created some uncertainty. I think what that would be interesting to learn more, and probably to get, to have a discussion on, and I'm looking for your question, is how you're living this through from a practitioner standpoint, whether you think there is an inclination for one of the other, one of these tools to be used, strengthened, introduced, if we don't have one yet. So with that, Markus, I'll hand it over back to you.
Thank you very much, Lorena. These were very interesting insights, and we already have received quite a number of questions. The first set of questions are from participants who would rather not be named personally, so if I could place them on the panel as they have come in. The first one, I believe, is for John. What are some of the biggest obstacles that you see that would obstruct achieving the shorter, longer-term political solutions that you mentioned earlier?
Thanks, Markus, and thanks for the question. Well, I mean, one of the things to keep in mind on the U.S. side is, of course, where we are in the political calendar, and the fact that we have an election coming up in a few weeks. One of the things that's obviously been discussed in the past, for instance, Privacy Shield annual reviews, is whether or not there are certain laws that should be changed, and that seems unlikely to happen in the short term. But the good news is that all legislative and administrative options are on the table to address the court's decision, and it appears that both the U.S. side and the EU side are actively and creatively thinking about different solutions, including what can be done administratively. When we think about that, the other thing I'll mention again, I mentioned it earlier, but on the U.S. government surveillance front, one of the things that also isn't necessarily reflected in the court's decision are various additional safeguards that have even been added since the 2016 Privacy Shield adequacy decision itself was ratified by the Commission and the member states. So there really is a lot that there are very, very legitimate questions, and we can get into this as to whether or not, you know, the laws and the protections that are in place in the U.S. Are you know, actually transparent and protective, and how they stack up with other surveillance laws around the globe. Longer term, when we're talking about something like a multilateral solution, we of course need to acknowledge reality that is not going to be a short-term fix, and it's going to take a long time and involve a lot of different countries working together. Whether we're talking about something like an OECD process or even, you know, potentially a treaty type of mechanism down the road, that is going to take a while. And then the one other thing, just to mention, you know, and I think a couple of other panelists have alluded to this. You know, this is not something overall that can be solved just by, just by the data protection authorities, or just by surveillance and law enforcement authorities, or just by trade authorities. You know, the reality is we really need all the different parties who are relevant to this conversation in the same room together. And, you know, and even in the commission itself, you know, you have different parts of the commission that are talking about, you know, different aspects of data in different ways, and really getting everyone on the same page politically in the EU, in the US, and globally is something that is, you know, it's going to be a challenge, but ultimately it has to happen.
John, thank you very much. We also have a question for Frank Ingenrieth. That was, you alluded to codes of conduct and other compatible self-regulatory mechanisms. Would you believe that these will be broader codes of conduct? Would you believe this would conflict with sector-specific compliance certification requirements? How would you see the mid to long-term horizon on these kinds of self-regulatory instruments? Are we going to be looking more at a sector-specific regulation, specifically tailored, more at a generic regulation? How do you see these developments?
I think it will be a mixture of both. For example, if you take the European Cloud Code of Conduct, it's addressing the full cloud industry, which is kind of broad, let's say, scope. On the other hand, you might also think of having a third country code of conduct without having any sector underneath. I personally think, especially considering what we did have from a discussion point of view, as an exchange with the authorities, I think they're kind of hoping that codes of conduct will have a kind of sector-specific approach. The sector doesn't need to be boiled down to very narrow, let's say, banking, health, or whatsoever. But for example, having the broad scope as the cloud industry will help them, because they are expecting that, especially when you take the safeguards in place, and it was mentioned by some other panelists today already, the ECJ somehow pointed out data isn't just data, and a country isn't just a third country. So the ECJ ruling allows for a kind of, I don't want to misuse the risk-based approach, but it allows for a case-by-case analysis. And a case-by-case analysis to be clustered into certain specific requirements is much easier if you have at least a kind of narrow scope for a kind of sector. So on the one hand, I do believe there will be sector-specific approaches, but on the other hand, I'm not believing that those sector specifics will be very detailed, but there will be room for broader sectors.
Thank you, Frank. There is one comment which I believe would be relevant to both Mathias and Lorena. It relates to the question of the nature of certain assurances under the previous EU-US Privacy Shield. And our participant here asks us, would it not be an accurate statement that these assurances under the previous Privacy Shield were essentially self-proclaimed assurances with little or no possibility to be verified, except, of course, if there were an actual court case, if there were an actual case like, for example, the Microsoft search warrant case a couple of years back. And ultimately, would the judicial redress that is going to be offered, was going to be offered under the Privacy Shield, is probably going to be a part of upcoming regulatory talks, would that really be sufficient? So how would you see this? Did you see in your professional experience, and certainly using these kinds of instruments, perhaps first, Mathias, your opinion, and then Lorena, if you please, would you have seen this as a self-proclaimed assurance, or did you believe there was some more substance behind it which warranted more trust than apparently the person raising the question would have had instilled in these regulatory instruments?
Yeah, thank you also for this question, which is quite a long one, which I think we need to break into several segments of it. So first of all, let's see that the Privacy Shield, as well as Safe Harbor before, and possibly also what we are going to see as in the future now. This is first of all something that's been agreed between governments. So this is a framework where basically two governments have said, okay, this is what we can do and what we cannot do. And if you read the text of that slowly, you see certainly that not all points have always been resolved. So there are different positions behind that. That's not something that we can ever forget. So that's probably the first thing. The second thing is that I do believe that all these proclamations, as they were called, or basically the agreement made, is something that both parties have made in good faith. However, due to the discrepancies that are in there, not all of the dissent that is in there has been fully covered. So I wouldn't say this was this was not worth anything. This was already a first kind of possibility to come closer together, and we now see an evolution of that probably going forward. We as companies, of course, as the industry, we have relied on that as well as on the standard contractual clauses, because of what I think everyone has alluded to, the importance of international data flows and data transfers. So we have served our customers, not only customers, but also individuals who are dependent on the international data flows. And we need instruments that we can rely upon. As much as one of us on a personal level might challenge that in the background, whether this is all as it should be or not, but ultimately it was a solution that there was a general consensus people could agree upon. So that's the thing as I would see that. What would I expect for the future? I would expect that the open topics that have now been exposed more blatantly, that they're being rediscussed, and that we find a way forward on how to deal with them, as it's become very evident that privacy has not only become is not only a thing that's of important for the Europeans, but that this is something that's on the increase globally. And I can also say, if you look at at California and other US states, also in the United States. So I would see an improvement there for the going forward as well.
Thank you, Matthias. I think I agree with everything obviously you said. I will also offer a bit the implementation, what it looks like to rely on these options, if you like, to secure and legitimize your transfer. I think there was a question, no, Markus, around how much of these requirements were actually difficult to implement and whether they would offer a certain level of assurance. I think my short question is that they do offer the right assurance. So just because, as I said, at least for where I come from and from my experience, there never have been just a simple exercise that we sign up to it. For the Privacy Shield, we always had a third-party oversight that will look in the way we will implement those requirements, including the redress mechanism that was also there for the company. Same thing goes for the SECs, which are quite restrictive and descriptive about how we will allow people that will feel in danger, or whether their privacy was put in danger and their data not kept safely in this transfer, that they will have an opportunity to obviously request information, have their data deleted, request more information on the contractual arrangements and so forth. Not to talk about the BCRs, which they have a full part of it, which takes care of the fact that the company needs to demonstrate that they have a way to actually interact with individuals that want to ask questions about their data and with their transfer, that how will support them, not only from a legal perspective, but also from a technical and procedural perspective. So I think all the mechanisms, they do have a good level of reassurance. From a privacy perspective, what I will offer, however, is that here the problem is that we're mixing fear from national security with privacy, which they obviously are connected, but it seems that we are now discussing data localization requirements in a privacy space where data localization is much broader and connects to other requirements that we should be discussing, which goes well beyond what is required by the GDPR itself, right? The GDPR has never been about localizing data in Europe. You could transfer data as long as you have reliable mechanism to transfer data to it. So I think there is, right now we're living in a moment where it seems where all is connected, but also a lot of things have an overlap. And we're attributing data localization requirements to SCANS 2, while it's a much broader discussion that and more related to cybersecurity, to the discussion at government level, not necessarily for privacy to solve. So hopefully that was my question, it was my answer, and hopefully it was satisfying for you, Markus.
Absolutely, thank you very much, Lorena. And before I'm addressing the next question that's been raised to John, perhaps from this transnational and transoceanic perspective, would you like to add anything to that perception that had been shared in the chat earlier?
Yes, Markus. Just a quick point. It is. I mean, I think the implication of the question was that, and apologies if I misunderstood it, but it seemed to be that hey, it's a voluntary program. Is compliance really meaningful? And I mean, I guess I just wanted to point out that of course, signing up to the Privacy Shield, it is a voluntary program administered by the Department of Commerce. But once companies do sign up, compliance with the principles is compulsory, and it can be enforced by is enforced by the U.S. Federal Trade Commission. So I mean, there is definitely there are consequences to companies signing up and then not keeping that high level of protection that is guaranteed by the principles that they're signing up to. I just wanted to make sure that was clear in response to the question. Thanks.
I believe, John, anyone who even looked at the enforcement statistics under the old Safe Harbor program, which dates back, of course, to before 2015, would know that the enforcement statistics on the part of the Federal Trade Commission were fairly impressive, compared to many, I would have to say, European Union countries at that point in time. So I would say it's a problematic view to say it's just window dressing compliance. I think there was much more to it. I wonder if you could share, there is another question, I wonder if you could share your view on one particular point. If I were negotiating on the side of the United States, if I were negotiating a follow-up program to the Privacy Shield, I would be tempted when I look at the regulatory framework in the European Union member states, especially with regard to repressive or law enforcement type surveillance, preventive types of surveillance, and also strategic telecommunications surveillance, I would be sorely tempted to introduce elements of reciprocity in the protection and to basically afford the same type of protection to EU citizens that US citizens are being afforded in the European Union member states. And that would raise, I would say, a lot of interesting questions that the EU member states themselves have to have a hard look at their own regulatory framework. How well are they even protecting their own citizens? And if you look at this is what the question alludes to, if you look at the Cloud Act and the reciprocity it includes, for example, Germany fails the reciprocity test on 2 counts. This, I think, is a bit of an issue. How would you see the negotiation tactics going forward? Would there be an element of reciprocity that makes it a bit more difficult for European Union member states to achieve the same level of protection that the US affords in certain sectors? How would you believe that is going to go from a tactical perspective?
Well, I mean, thanks for the question. I think it does raise some very good points, and I think, and I alluded to this in my opening comments. I mean, I think there are, number one, the requirement, and again, I agree with the comments made earlier. I mean, obviously, the court's decision does require a case-by-case basis, and I think the point has been made a couple of times. Not all data is the same data, and not every company is in the same position. Clearly, not every third country is in the same position. I mean, but to the extent that the court's ruling is requiring companies to assess third country surveillance practices, I think it is a very fair point to be raised. Number one, as to whether or not many other third countries compared to the US, who have, frankly, far less transparency with respect to their surveillance practices, you know, and arguably less protections could, you know, meet that essential equivalence standard, number one. And I think with respect to the question in the EU specifically, you know, it is a very good point, and you know, there have been various analyses of member state surveillance practices and laws and other laws, and I think it's a very fair point to ask whether or not European member states could meet the standards that are set forth under the Court of Justice opinion as well. I mean, I think the question is, of course, how will this manifest itself in a potential agreement? You know, I think again, I think anything is possible, but I think in terms of the shorter to intermediate term solution, you know, I think from my perspective anyway, I hope that the parties are constructive in looking for solutions as opposed to you know, starting to make reaching an agreement more complicated in the short to intermediate term. But I do think in the longer term solution, really having a serious conversation about what are the criteria that, you know, like-minded countries should be using in this space when we kind of juxtapose not only privacy protections, but surveillance practices and government access requirements, you know, all of which are, it is a reality that all countries are, you know, conducting surveillance and collecting data for national security purposes, for law enforcement purposes, and we need to figure out what are the protections that are you know, legitimate and that should be in place to protect fundamental rights and other issues. And I mean, I think you mentioned the Cloud Act. I guess I'll just leave you with this thought, which I think also goes to one of the points I was making earlier. You know, the European Union itself and you know, is pursuing you know, a Cloud Act agreement with the U.S. So clearly there is a desire on the part of some European authorities to actually be able to you know, share data for law enforcement purposes. So we really need to look at the big picture, I think, when we're talking about that. Thanks.
John, thank you very much. We have one more question for Frank, actually. You alluded to the codes of conduct and also the role that they could play in self-regulation, but at the same time, we can't help noticing the European Data Protection Board really hasn't issued any guidelines yet on codes of conduct. Do you think these codes of conduct as a self-regulatory mechanism are being appreciated, and how do you see their evolution going forward in the midterm?
So first of all, yeah, I do think they do appreciate it. So we did have some other panels in this regard, and they certainly highlighted that they would like to see codes of conduct evolve in this third country safeguard environment. And as there are those guidelines regarding general codes of conduct, we are specifically awaiting, and they promised that they will possibly publish such guidelines for third country safeguarding codes of conduct even this year. So that they are knowing that there is a need of that, and they're kind of prioritizing. And I would also like to highlight that this is going slightly in regards of this monitoring, because codes of conduct are mandatory being monitored. And there was a session with Professor Kugelmann this morning, who is the supervisory authority in Rana-Palatinate. And he mentioned that there are discussions, for example, regarding the SDPCs or the future SECs, that there might be a need of having a kind of monitoring scheme. And he explicitly mentioned that he's certainly considering codes of conduct to being developed as a kind of progress, and I personally would agree. And I also would like to say that this kind of monitoring is specifically helping small and medium-sized enterprises. We mentioned those case-by-case analysis, and I really do wonder whether a small electrician or a small hairdresser whatsoever is capable of analyzing a third country's jurisdiction. I presume those small and medium-sized enterprises will not be capable of doing that. And having a kind of legally respected and endorsed mechanism like a monitoring body in place that is doing that for them is kind of outsourcing, would, I think, highly be appreciated by small and medium-sized enterprises, because otherwise I do think the country transfers for them are being kind of dead in future.
That's a very good point. Thank you for that, because we have a corresponding question which I now would like to pose to Lorena and to Mathias, which exactly picks up on your last point but transforms it to the larger enterprises and asks, is it realistic to expect even larger multinationals to complete an assessment of a target third country that, in preparation for an adequacy decision, takes the European Commission several years, now within a certainly much more limited period of time? To what extent do you see that as being realistic, and is perhaps the European Court of Justice here proposing requirements that can't really be met? Perhaps first, Lorena, your thought, and then Mathias, if you please, yours.
Yeah, I would say it's not an easy job, even if you have all the capabilities and all the all the resources that you can get, right? Also because and that's very much, privacy is contextual, don't forget, and so it is also the data that you're transferring and the purpose for which you're transferring. So to some extent, there is also some more elements that you need to take into account when assessing the law that it's receiving the data, to what extent and to what level is providing a reasonable certain of protection for a certain type of data. So it will always be ad hoc, it will always be contextual, and it will always be complicated, just because every time you will need to have that assessment on ad hoc basis. That's why it's not sustainable, and that's why normally it should be for governments to agree whether the laws do have the same level of protection, right? That's why the whole point of having adequacy decision was there, and that's why there are now in the GDPR. When the adequacy is not there, then it's for the company to allow certain type of transfer, not like allow and assess the third party, the third country overall law. That's not for the companies to do. So I would say, it's an unsustainable model. It needs to be fixed, and certainly I very much agree with John and the rest of the panel that said that we absolutely need a government-to-government agreement here sooner than later, I would say. Thank you.
Thank you, Lorena. And perhaps, Mathias, your thoughts on this in addition? Then I have, after that, one final question for the entire panel.
Okay, I would basically just first of all say, Lorena, thank you. I agree with everything that you just said about this here, and I would like to spin this a little further. I mean, the European Commission, when they did an assessment, or when they do an assessment about the adequacy in a certain country, that's very holistic in its entire scope. When a cloud provider like SAP does that, we can be limited to the circumstances around our cloud services. So that is something that would make it a little easier. But that doesn't help you, because ultimately, first of all, the obligation to do an assessment, that's with the controller, and that's not us, that's our customers. So all we can do is we can provide our position for the customer to consider. The question now arises, what happens? And that's the deeper questions. If someone in a supervisory authority or someone else on whatever kind of level would say SAP's assessment, which a customer would rely upon, is actually wrong, they disagree with this assessment, what consequences would that have? Is the obligation only to do an assessment, to be thorough in this one, or is the obligation to be on point with the outcome of that assessment? All these are open questions which show you how difficult and vague this task actually is going to be, and how difficult it will be to handle the legal consequences that arise from that. Also, from that respect, I think it's now in everyone's interest if all the stakeholders, governments, supervisory authorities, industries, but everyone says, hey, we are in a global economy, we need rules for international data transfers. We are not shuffling paper back and forth anymore. We need now to adapt also our practices in law enforcement. We need to adapt the way we look at things between governments, and truly provide a true framework for the economy of our times.
Thank you very much, Mathias. So actually, I can now limit the final question to John and to Frank, because you've already nicely addressed the points I was going to, and probably also the person asking that question was going to get at. Do we really now see another instance where the industry needs to fix what governments working together could not do in time. Perhaps one closing sentence by John and by Frank.
Okay, then I'll go ahead. I'm not sure whether it's another time where industry needs to fix something that governments have failed to fix, but what I experienced when having exchange with respective representatives of the authorities of the Commission, they do highly appreciate any industry support. They are aware that there are certain aspects that industry cannot resolve, for example, conflicts of laws. They're perfectly aware of that industry cannot resolve those issues by themselves because it needs legislators to act, but they are certainly happy for any support because, as Mathias already pointed out, industry does have a very in-depth knowledge in certain sectors and for certain issues that come up on a day-to-day basis. So yes, I think the industry doesn't have to fix something government has failed, but it's now the time that industry gathers and joins to support governments in resolving an issue at hand.
Thank you, Frank. And perhaps, John, one closing sentence?
I mean, I agree with Frank that industry does need to support the government stakeholders involved here, and one of the ways that industry can support the government stakeholders is actually by bringing good ideas to the table. I do know that both the Commission and the Commerce Department, at least, are actively talking to industry and soliciting ideas, and they want to know what companies are doing in the short term to try to use the mechanisms at their disposal to help protect fundamental human rights and while allowing the flow of data. Ultimately, though, it is going to take a government-to-government solution in the longer term, and all the stakeholders working together, as I previously mentioned. And I guess I would just close with a statement someone else made earlier. It is not a time to lose hope, but we do need to keep, as industry, also impressing upon the need, our government partners, that we want to work with them, but we do need to get solutions that are going to be more durable than Privacy Shield proved to be.
Thank you very much. With that, I would like to conclude this afternoon's deep dive panel on international data transfers. Thank you very much for the very lively conversation. Thank you to our great audience for the many questions. I hope I'll be seeing more of you in the other sessions that will still be conducted this afternoon. It was a great pleasure having you. Thank you very much for your contributions, and have a very, very good day and be safe.
Thanks.
Thank you, Markus. Bye-bye.
As well.
Bye-bye.
Thank you, Markus.
Bye.